the arguments that are being presented by the Solicitor General. Quickly opening this up with our guest joining us this evening, we have Mohan Krishna, spokesperson, Karnataka BJP. We also have S.S. Sriram, who's a political analyst with us. Also with us is Desh Ratan Nigam. We have Shahid Ali and Touseef Ahmed on this broadcast. Thank you, gentlemen, for taking out your time. An all-important story, and any minute now we can hear something concrete coming from the three-judge bench. Now, from the two-judge bench, the matter was referred to a three-judge bench. Given the difference of opinion amongst the two judges who were earlier hearing the case out. If I could begin with you, Touseef Ahmed, you know, now Mukul Rohatgi says 15 years ago when similar issues arose, an informal committee was formed including the Minister of Waqf, and kindly see, members agreed to allow use of ground for Dussehra, for Shivratri. So why this decision that was taken 15 years ago cannot be repeated or revised once again? He goes on to say that perhaps it's time for us to be a little more broad-minded. Perhaps it's time for us to stop thinking about what happened in 1964. It's a ground that must be used by all, for all religious purposes and cultural events.
You see, it is one thing for any party to come before a landowner to say to him that you are the landowner and I seek your permission to hold a certain things, to do a certain activity. And if that permission is not granted, then that's a question of debate. But it is another thing to come and say that, oh no, you are not the owner at all. To dispute the very fact that from the last 200 years, this was a Eidgah land and continues to be the Eidgah land. No other religious activities were taken other than Eidgah, other than Muslim religious activities. No, it continues to be the Qabristan. Today what is happening is this commissioner in 2022 has passed a notice and challenging the entire factual aspect that this land does not belong to you at all. This land belongs to state and we will do whatever we want. And that is challenging the entire judiciary and entire justice system. Okay. If you want to challenge the justice system, if you want to devoid Muslim bodies of the land that they hold, or if you want to devoid the Waqf board of the land that they have listed as Waqf property and which continues to be used as Waqf property from last 200, you have to pass a law in the parliament. You have to abolish the Waqf Act and you have to declare that the land belonging to Muslims shall no more belong to them if it is a Waqf property. You have to pass the law.
This has not been used by anyone else but the Waqf for the last 200 years, then status quo must be maintained, and that's what is being argued by Kapil Sibal also since the beginning of this very case. The moment the Supreme Court took it up, he went on to cite the 1964 judgment and went on to say that since this has been used by the Waqf board for the last 200 years, why make any sort of changes now? Desh Ratan Nigam, sir, if you could just come in and explain to us as to what do you really feel, because up until now what's also happened amidst all of this, the last couple of months we've seen the state come out, the BBMP come out and demand certain documents from the Waqf board, say support it with documents, and perhaps then it will be taken into consideration the way the Waqf board wants it to be taken, but none of that has happened either.
Yes, absolutely. When you ask for documents, to kagaz nahi dikhayenge. That's the standard thing. However, whatever is going on Supreme Court is something which the root of the problem has to be addressed to. The root of the problem is, since the Mughal times, if there is a property which has been vested, it cannot be, considered so as under the Constitution. It has to be considered under the Constitution, and Waqf Act is under challenge in Supreme Court, and probably some kind of a decision will come out. Yes, one of the properties of Hooghly has been claimed by a municipal corporation and the other one is by the revenue department. And let me tell you, the property tax is collected by the state governments so far as Waqf land is concerned. The properties built on these lands, the property tax is taken by the various state governments. So that's another issue which comes into the picture. How can any property tax go to the state government when there is a Waqf Act. So there is exceptions carved out already under the law. So various issues are there, and these issues have to be decided because Waqf is sitting under huge amount of government land. These are government lands. Somebody gave it to you, the Mughals gave it to you, the kings gave it to you, will not suffice into modern times. And that obviously an act which was passed surreptitiously, and that act is under challenge, and I believe all these questions will go into that. And there is a very clear communal angle and political angle is being given. Earlier, you know, what was being done was, since the elections is there in Karnataka, therefore this is happening. You recall Mr. Kapil Sibal had raised exactly the same point in Ram Mandir case for its postponement. So the communal angle is also
Mr. Desh Ratan Nigam, while you're talking about the communal angle and perhaps how it's associated to the upcoming Karnataka elections, there's a quick update coming in. The Solicitor General says in the absence of any claim for title and when there is a revenue authority record showing it is with the government, the division bench committed no wrong. The division bench judgment is something that is being questioned by the Waqf Board. So you have the Solicitor General stepping in and defending the judgment by the Karnataka High Court, the division bench. Goes on to say, and this is important, now I have a suggestion to balance the equities. Please allow us to permit a government-managed temple to hold Ganesh festival only for tomorrow and day after with the responsibility of the government without putting any permanent structure, and we will take care of law and order. So this is important because now the Solicitor General has come out and said that we will vacate it later, to which Dushan Dave says such an assurance was given in the Babri Masjid case as well. This undertaking was violated. Shahid Ali, if I could come to you, what is the problem then if it's just about 2 to 3 days and, you know, a festival that is celebrated across the country, an attempt is being made to host that festival on a playground that the Waqf Board claims is rightfully theirs, but it's just a matter of 2 to 3 days.
I am really unable to understand why all times Pandara box are being opened every day at different places in the name of different things. See, this is a mosque or this is a Eidgah where the namaz is performed, and there are two distinct religions. One is Hinduism, one is Islam. Hinduism always advocates for diet and worship of gods and goddesses, but Islam believes in oneness of God. So this distinction has to be understood. A property which is being used for performing namaz for last 200 years, and of course for playing by children. As far as the public purpose is concerned, as far as the public utility is concerned, that is different than the religious utility. So these things, two things cannot be equated with each other. This has to be understood. Now, why you have been asking for Eidgah all of a sudden after 200 years? Why this time only?
How does this
is a question of great importance. Now, everywhere the politics.
Firstly, let's not, you know, individually try and pick on different religions. That's not what we're here to do. We're just trying to break down details of what's happening in the top court.
That is the belief. That is the belief.
All right. Anyway, the top court, the arguments are currently underway, and we'll come back to the point that you're making. But an important update coming in with regards to what has been said by Dushan Dave, and this is important, viewers, because now Dushan Dave has made it amply clear and he's pointing out the Babri Masjid analogy. That's what he's trying to bring in at this point in time. Details of the same on your screens, how such assurances were given during the Babri Masjid demolition as well, and all of those rules were violated. Mr. Mohan Krishna, if I could come to you now. What is the need of bringing in the Babri Masjid case at a time that, you know, this case is being taken up by the top court? Now the Waqf Board is saying that this is, you know, an issue that dates back to 200 years, that they are the rightful owners of the Eidgah Maidan in Bengaluru, and so no changes should be made. The fact is that this controversy broke out, you know, during the 75 years of independence and the celebrations around it, and people now growingly demanding that everyone be given equal right to use a public property. That's what people are saying. That's how this entire controversy first broke out.
Kritsween, Shahid Ali is also very clear in his thoughts and intentions. He is making it clear to the nation today. As Kapil Sibal is arguing and Dushyant Dave is arguing in the court hall there. What is your problem, Shahid Ali? If you are lying to the country, where is the namaz being done there? Occasionally, in Bakrid, in Eid days, except those days, every day it is not there. It is just a Eidgah. Eidgah means what? You are going there for only prayer, not for namaz. You lie to the country? Come on. We are not here to listen to you, all the lies you are telling to the country. Coming back to the point. What is the problem? Are you not broad-minded? Are you such a narrow-minded people?
Read Article 25 of Constitution of India
See, now, all this time I was observing you.
Sir, please read Article 25 of Constitution of India.
You are not talking about Constitution.
You people have been violating the Constitution openly. You have no respect for the Constitution, for the law of the land. You have no respect for the Constitution, law of the land.
That is why we are
Article 25 confers fundamental right on all citizens to perform their own religion.
But where is the title? Title is not in your name.
We should sacrifice everything.
It is in the state.
We should sacrifice everything.
How can you claim that it is yours? How can you claim that it is yours?
We will celebrate.
You know, while you're asking those questions of Shahid Ali, there's an update coming in. Justice Banerjee. I need to come in here. There's a court update coming in. Justice Banerjee says, that's an oral observation by the way, let status quo be maintained, to which Justice OK says, see, for 200 years, no such thing happened in the land with regards to this particular property. Why now? So that's what the judges are pointing out. Now, if I could come to you, Mr. S.S. Sriram, now a lot of political blame game also, ensuing. You have the Karnataka government certainly at this point in time saying, let's not make it a big deal. It's a matter of 2 to 3 days. But the fact remains that the 1964 judgment was very much in the favor of the Waqf board. And that's what they're citing. That's what it's all boiling down to, because they're saying that why make changes?
Basically, it is not
why not go back to status quo? Why should status quo not be maintained?
No. The last 2 days or so were multiple statements of our own Muslim friends saying that the title is not theirs. They themselves have agreed over the channels even yesterday. So there is a clear ambiguity as to who owns the land. And that being the case, why can't people who give lectures on secularism, people who give lectures on brotherhood, why can't they themselves come forward to allow the Hindu brothers to celebrate the festival for a day or two max?
Absolutely.
Now this is definitely, there are situations where Mr. Syed Ali talks about constitution. There are highways being blocked on Friday for namaz. Hours together, people are held on the roads for them to clear the roads. And is that a constitutional right? Not so. The constitutional right, as far as Mr. Syed, people like Syed Ali will only use which is convenient to them and not a general public at large. Now this is
But Dushyant Dave is saying that these assurances were given in Babri Masjid case as well, and all of those undertakings were violated.
Then nobody wants to go and celebrate it in a dargah or in a mosque. This is a land which is open for all. This is a land where there is no clear ownership or title for any specific community. Why can't the land be used for others as well? That's a simple question. And why can't the people who talk secularism and brotherhood come forward to allow that to happen for a day or two? And that is all about it. So where is the question of not being allowed to do is my humble question, please.
Okay. Mr. Desh Ratan Nigam, that's the question being asked. Also, now Kapil Sibal, while he's putting out his arguments, says that status quo has to be maintained. Balance of convenience is in our favor. They've not interfered for 200 years. Why now? Talk about Dushyant Dave, talk about Kapil Sibal. All of them are arguing on the very same line. If for 200 years, 200 long years, no changes were sought, why this kind of an intervention now?
See, the fact remains that nobody is changing the status quo. It is being only used for 2 or 3 days. The title will be finally decided. That is already a subject matter of dispute, and therefore this is not changing the status quo. Status quo changing means taking over permanent possession or changing the title of the land. I think any lawyer can understand, even a common person can understand.
Absolutely.
It is only for the purposes of these 2 days. That is all. And it is all subject to final outcome. Today only interim status is being argued. Finally, whether the Waqf Act will remain or not, or whether the Waqf board has a title or not, who has the title, these are questions will be finally decided in a trial. Title cannot be decided in Supreme Court or otherwise. Therefore, nobody is changing the status quo. In the name of status quo, they are trying to prevent the legitimate aspirations of a community. That is what I am trying to say. And these so-called secularists, when it comes up to them, then they will start, carrying the Islamic, flag with them. The whole problem arises the selective nature of, what you call protest, which is there. Now, remember the appointment of a Christian in Tirupati's trust board. Please remember the Kali Mandir in Calcutta, where a Muslim has been appointed on a management board. Why all these things are happening? So we must remember that this is a land and 200-year-old titles, all this is subject matter of dispute before the court. So this is only a permission to a limited extent of celebration of a particular Ganesh Chaturthi and a festival taking place. And I don't think anybody should have an objection to it. Finally, everything is sub judice before the court. The court will take a final call on the title and the ownership.
Okay. Touseef Ahmed, once again, why claim that, the land is rightfully yours when you failed to produce the valid documents that were sought? So why, while you've not been able to prove that that land truly belongs to the Waqf board, are these claims being made? Because the fact of the matter is, one can't keep just quoting the 1964 judgment without providing enough facts. 1964 was long ago. The fact remains, there is an argument being presented wherein it is being said that it's time for us to be broad-minded. It's time for us to make sure that there is no disparity with regards to cultural events, with regards to religious events on any such property. Talk about, festivals related to the Muslim community or the Hindu community or any other community for that matter. Touseef Ahmed.
I am.
All right, the big breaking news coming in. The court is currently dictating the order. So any minute now we're going to expect that big word coming in from the top court. And Justice Banerjee has said that status quo will be maintained. We were just holding a discussion on the status quo aspect of it and how Kapil Sibal and Dushyant Dave went on to say that status quo must be maintained if nobody has had to organize any such event on this land for 200 years. Why this kind of an intervention now? And with regards to the order, Justice Banerjee has said status quo will be maintained. The Supreme Court has ordered status quo as of today will be maintained is what the top court is saying. Especially petition has been disposed of. So certainly in that sense a setback coming in for the Karnataka government and a big victory in that sense for the Waqf board, because the Waqf board since the very beginning, be it the 2-judge bench and now in front of the 3-judge bench, has been citing the 1964 Supreme Court judgment, has been saying that the land is rightfully theirs. They have the sole claim on the land. They will do what they feel with that very land piece. Now let me go across to Nilashish, who's joining us with more details. This is big breaking news coming in, a setback for the Karnataka government, Nilashish, and victory for the Waqf board. All right, before that, Harish is joining us on the phone line, our legal editor who's been getting us all those details from the top court. Harish, over to you.
Yes, so that's right. It's a huge setback for the Karnataka government and the municipal corporation, as the Supreme Court has set aside the judgment of the ruling of the 2-judge bench of the Karnataka High Court, which had in fact permitted the Karnataka government and the municipal corporation to hold the Ganesh Chaturthi celebrations in the Bengaluru Idgah Maidan. But today, the Supreme Court order has said that the status quo has to be maintained, and in fact the Supreme Court bench led by Justice Indira Banerjee found merit in the argument of Kapil Sibal, who had appeared for Waqf board, that the balance of convenience was in their favor, because for the past 200 years no such celebration had been done, was not permitted, and prima facie, even in the revenue records showed that this land was a Idgah land, and continuous revenue records proved that the land belonged to the Waqf, and therefore no such celebration could not be permitted by upholding the rights of the minorities communities to administer their property. So, remember during the hearing, the Waqf Board had also cited the Places of Worship Act, which said that status quo has been maintained as of 15th August 1947. So it's a huge setback for Karnataka government and municipal corporation, as Supreme Court has disallowed them to hold the Ganesh Chaturthi celebration in the Eidgah Maidan.
And with regards to the last leg of the hearing, Harish, already look like things are going to be turning in the favor of the Waqf Board. But as far as this order goes, what about the longevity of this order? For how long does this order stand valid? Are we just talking about the next 2 to 3 days that were the bone of contention here with regards to the Ganesh Chaturthi celebrations?
Yes, that the entire prayer was for allowing the Ganesh Chaturthi celebrations scheduled for tomorrow and day after. The Solicitor General Tushar Mehta, who had appeared for the Karnataka government, vehemently pleaded that at least even Mukul Rohtagi said that the one should be broad-minded and look at the celebrations. Otherwise, the Solicitor General said that at least for 2 days allow the celebrations, and day after tomorrow the ground will become back to normal, and all these temporary structure will be dismantled, and the status quo will be maintained. But Supreme Court said that as of now, prima facie, the Supreme Court felt that the balance of convenience is in the favor of the Waqf Board, as for the last 200 years, no such celebration was allowed, and they had prima facie evidence that the land belonged to the Waqf Board, and in fact, so no such relief could be given.
Okay. And what about the options before the other side? What else can they do now? Well, we're just a few hours away from when the celebrations are to kick in across the state, but do they have any other legal options left with them?
No, since this matter has been, the order has been pronounced by the Supreme Court, as of now there is no legal option for them because the celebration is tomorrow. Remember, even the matter had gone to a 2-judge bench of Justice Hemant Gupta and another judge, and then from there it had gone to the 3-judge bench. So even today the matter had been heard extensively by it was a marathon hearing from 2:45 till now. Two benches have heard the matter, and finally the outcome is that the Karnataka government and Bengaluru Municipal Corporation has been asked to maintain the status quo.
All right, Harish, one last question. Now, we had Justice Banerjee and Justice Oka, both of whom opining that for 200 long years, none of this was done. So why make any sort of changes? Why not let status quo be maintained? What was the turning point during the course of the arguments that will be being presented by both the sides? Harish, can you hear me?
Yes, please repeat your question.
Yes, I was meaning to ask you as to, since you were witness to the arguments that were being presented by all sides, what was the turning point really? Because both Justice Banerjee and Justice Oka were of the opinion that status quo be maintained. None of this was brought in for 200 long years, so why now? What was the turning point really?
Yes, in fact, the turning point being that the Supreme Court, senior advocate Kapil Sibal and Dushyant Dave Dushyant Dave, in fact, pointed to the 1964 judgment of the Supreme Court, whereby prima facie it was observed by the Supreme Court that just because a place is an open playground, it does not mean that the property belongs to the state, and lengthy and continuous revenue records proved that this land in fact was an Eidgah, and there was a Supreme Court judgment also had in one of its parts
court said that there was a Qabristan in it. So, and even the Waqf board said that even the last 200 years, no such celebration had been allowed, and they also pointed to the Places of Worship Act, which in fact protected the character of a religious place, and said that status quo should be maintained as on 15th August 1947. So all these arguments were put forward. They had also vehemently argued that the single judge in fact had given an order in their favor, and also allowed modification of the order. But despite the single judge saying that there can be modification of the order, they had straight away gone to the double bench and got an order in their favor. And in fact, they also argued that this Maidan, this Eidgah Maidan, in fact, the religious structure of the Eidgah Maidan should be preserved, because this is part of the protecting the property of a minority community, and no message should go that rights of minority community were being trampled upon. So all these arguments were taken into consideration, and Supreme Court bench led by Justice Indira Banerjee repeatedly asked whether we have only one question: has such a celebration like Ganesh Chaturthi celebration been carried out in the Eidgah Maidan? But always the answer was no. And the Supreme Court also pointed out to the fact that there were several injunctions against the Bangalore Municipal Corporation, but Mukul Rohtgi, appearing for the Karnataka state government, said that the injunction was for building a school in the ground, not for getting for a passage, or not going into the Maidan. But Mukul Rohtgi also argued that the party before the Supreme Court is not the municipal corporation but the state, and whatever injunction was there was the injunction order was being passed against the municipal corporation and not the state.
All right, Harish, now what about the division bench judgment? Because, you know, it did come across as, at least until a few hours ago, that all was in place for the government to just give a go-ahead with Ganesh Chaturthi celebrations at the Eidgah Maidan, and that was, of course, in modification to what the single judge bench had ruled. So what happens next?
Yes, now in fact, remember the Karnataka government and the corporation had suffered a setback from the single judge or single bench of the Karnataka High Court, but then they had rushed to the division bench, which had given them relief, saying that they can issue orders regarding the celebration of the Ganesh Chaturthi at the Eidgah Maidan, but against which the Waqf board had come to the Supreme Court. From here, the Supreme Court had in fact restored the single judge order of status quo at the Eidgah Maidan. So as of now, since the order has been passed by the Supreme Court, that order will prevail, and the order of the division bench of the Karnataka High Court, which had allowed the Bangalore Municipal Corporation and the Karnataka state to hold the Ganesh Chaturthi celebrations at the Eidgah Maidan, will stand scrapped, and what is the meaning of the Supreme Court order is that the Bangalore Municipal Corporation or the Karnataka state government cannot host any Ganesh Chaturthi functions tomorrow or day after. And remember, tomorrow is the day of the Ganesh Chaturthi festival, and there is no time left for the Karnataka state or Bangalore Municipal Corporation to even file an appeal.
That's the final word coming in from the top court, and a big relief for the Waqf board in that sense. No Ganesh Chaturthi celebrations with regards to the Eidgah Maidan, as was being contended by the Waqf board. Thank you, Harish, for joining us and giving us all those non-stop updates from the top court.